Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back to Civics in a Year. I'm very excited to have Professor Stephen Wermiel with us to talk about Baker versus Carr, which is one of our Supreme Court cases. And if you are an AP government student, it is one of the ones that you have to know. So, Professor Wermiel, what was at stake in Baker versus Carr? And how did the Supreme Court's decision to change the court's role in addressing issues of political representation and fairness?
So Baker versus Carr is a really fundamental case about our system of voting and representation. And it really goes to the core of who we are as a democracy. Prior to Baker versus Carr, many states, maybe even most states, had just vastly disparate sized legislative districts. When we're talking about the makeup of the state legislature, let's say the state legislature has a House and a Senate, just like the Congress. The state legislatures before Baker versus Carr, many of them had not changed the size or shape or number of people living in their legislative districts for years and years and years. Baker versus Carr itself came from Tennessee. And so, for example, it was decided in 1962, Tennessee had not redrawn their district maps to reflect changes in population since 1901.
Oh.
1901 to 1962. And so what was happening in the country, not just in Tennessee, but all over the place, was vast migration in the early 1900s to the mid 1900s from rural areas to cities. The population of cities was increasing dramatically, and the population of rural areas shrinking. What that meant is that you had legislative districts that once had been smaller, that now had huge numbers of people in them, but the representation wasn't changing. So one of the more dramatic examples was the Supreme Court had decided an earlier case in 1946 from Illinois. And in Illinois in 1946, one legislative district might have 100,000 people living in it, and another legislative district had 900,000 people living in it.
Oh.
So now think about what that means. The 100,000 people have one representative, and the 900,000 people have one representative. How is that equal? How is that fair? How is your representation equal to the next district's representation? The other problem, just to kind of lay this out a little bit, the other problem that happened, and it wasn't all in the Midwest and the South, when we first began drawing legislative districts in this country, in New England, the New England states did it by saying every town gets a representative. Well, so a town that has 1,000 people living in it gets a representative, and a town that has 10,000 people living in it gets a representative. And so it makes no real sense in how these districts were drawn. And the fundamental core question is, are you getting your fair share of representation? If one representative is representing 100,000 people and the next representative is representing 900,000 people, your ability to have your views represented is significantly less when you're living in a district of 900,000 people. So the question in Baker versus Carr, though, wasn't really all those numbers. The question in Baker versus Carr was, is this a federal constitutional issue? And up to 1962, the Supreme Court had said no, that this was a political issue, and it was best left to the legislatures and the voters. And so prior to the decision in Baker versus Carr, you couldn't really go into federal court and say this scheme of big district, small district, same number of representatives violates my constitutional right. The Supreme Court would have said, sorry, you're in the wrong place. Go complain to the legislature. So the significance of Baker versus Carr is that the court basically opened the courthouse doors to claims of what we call reapportionment. Mm-hmm. Reapportionment meaning you're realigning, you're reapportioning legislative districts to reflect accurate population numbers. The Supreme Court opened the doors to those cases being federal constitutional cases. And that led to dramatic changes all over the United States. So it's often said that Baker versus Carr produced the notion of one person, one vote. And that's true, but it's not quite accurate. What Baker versus Carr did was say, you can come to federal court and say that this disparate representation violates your guarantee of equal protection of the laws under the 14th Amendment. But that's all we're doing in Baker versus Carr. All we're doing is opening the courthouse door to those kinds of cases. It took a couple more years and a case called Reynolds versus Sims in 1964 for the Supreme Court to come up with the one person, one vote standard. So in a sense, it's really two steps. Baker versus Carr invites you in, and then Reynolds versus Sims says, and here's the rule. And that's really the significance of that, is that every state in the country had to then redraw their legislative maps so that people were getting fairer representation, equal representation.
Interesting. So besides Reynolds versus Sim, what lasting impact does Baker versus Carr have on America's constitutional democracy, especially when we're talking about modern debates over gerrymandering or representation?
So in a sense, it's a good news, bad news situation. The good news is before Baker versus Carr, if you were in that 900,000 person district with only one representative and you felt that you weren't getting adequate representation because the person in the next district had one representative for 100,000 people, you couldn't really go to court to do anything about it. You could maybe go to state court, but you really couldn't go to federal court to claim that the federal Constitution had anything to say about this. So once Baker versus Carr opens up the possibilities, and then Reynolds versus Sims says one person, one vote, then the door is open to what we call gerrymandering, which is a process by which the political parties in power say, okay, if we have to redraw the district lines and it still has to be one person, one vote, but we're going to draw those district lines in a way that tries to maximize the influence and power of the controlling party. And to be fair, this is not a partisan point. Democrats do it when they're in power. Republicans do it when they're in power. So what they do is they cleverly draw weird shaped maps and so on to maximize their influence. If let's say it's the Democrats drawing the map, they'll try to push Republicans over here into this district and over here into this district, so that the influence of the Republican vote is spread out and not concentrated, and reduces their ability to elect a representative. The Supreme Court has said that that doesn't pose any constitutional problem as long as two things. One, it's still one person, one vote. And two, as long as it's not based on race. As long as you're not drawing the districts to hurt minority voters, and as long as it's still roughly equal numbers of people living in each district, then the court has basically closed the courthouse doors to gerrymandering lawsuits. The court has said that gerrymandering lawsuits do not raise any federal constitutional issue. So they're almost like mirror images. I mean, we opened the courthouse doors to the idea that districts have to be roughly the same size so that everybody is fairly represented. But when we draw those districts to maximize one political party's advantage, the court says that's not interfering with your ability to be fairly represented.
So political gerrymandering is okay, but you said racial gerrymandering is not. Can you explain the difference in that?
So the racial gerrymandering arose, well, there's a case all the way back in 1960, but much more recently in the 1970s and 80s. There were places in the country where legislatures tried to draw maps that would minimize the impact of minority voters. They would spread the minority voters out among different districts so that the minority voters didn't really have the ability to elect a representative of color. And that notion is called vote dilution. We're taking the power of minority voters, and by spreading it out, we're diluting its impact. And the court basically said that raised race discrimination problems under the 14th Amendment Equal Protection Clause, and also under the 15th Amendment guarantee of the right to vote free of race discrimination. Now, that's a very timely subject because the Supreme Court is hearing a case from Louisiana this term where there's a good chance that the court is going to change its position and say you can't ever use race to draw district lines, and you can't go to court to claim that vote dilution based on race violates the Constitution or violates the federal law. So basically, for 40 years, roughly, you've been able to go to court and say, in the state that I'm in, they are drawing the district lines in a way that discriminates against minority voters. They're making it hard for minority voters to have their vote count as much. And it seems likely that the Supreme Court is now going to close the courthouse doors to that kind of claim. In other words, the state will be able to dilute the minority vote without risking a federal constitutional lawsuit. Now, again, the court hasn't ruled that yet.
Mhm.
They've heard arguments in a case called Louisiana versus Calais. But it seems like there's a good chance that they are going to take away some of the protection that has existed for against the discrimination against minority voting.
Professor Wermiel, thank you so much. I feel like you took a really big topic, not only political gerrymandering, but racial gerrymandering. And then you tied it all the way. Again, now I want to look up this case and kind of follow this with the Supreme Court. So thank you so much for your expertise. We appreciate it.
Glad to help, and great subject and very important to our democracy.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.